Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about the right to counsel in breath testing. Cases that should have gone to the Supreme Court of Canada, but didn't. The Criminal Code and the Charter function together to effectively prohibit people from having the right to contact a lawyer when they're given a demand to provide a sample into a roadside breathalyzer. However, in some circumstances, police do have an obligation to facilitate access to counsel. In those circumstances, if somebody invokes the right to counsel, the police have an obligation to hold off from obtaining incriminatory information about an individual until they've had the opportunity to contact counsel. Incriminatory information can include the results of a breathalyzer test. This is what happened with Mr. Drolet. He refused to provide a breath sample because the police had offered him the right to counsel, but had not given him the opportunity to contact a lawyer before asking him to blow into the roadside breathalyzer. He was arrested, taken back to the police station, and continued to refuse to provide a sample. He was convicted at trial, but ultimately on appeal, his conviction was overturned and an acquittal entered on the basis of the fact that his rights were violated and he had no legal obligation to participate in the incriminatory process. And this case raises important issues. There's a line in a BC Supreme Court judgment that says, how can a police error without more create a right that didn't exist in the first place? But it also complicates matters because the right to counsel doesn't not exist in the context of impaired driving investigations, it's merely suspended. So it could be unsuspended in the context of a situation where the police advise a person of their right to counsel. There are also numerous situations in which the right to counsel may arise while an impaired driving investigation is going on because of a concurrent or subsequent investigation into another offense that's been committed at the same time. And in all of those situations, determining when the right to counsel is suspended, when it exists and when it doesn't exist, and when a person has the right to contact a lawyer before providing a breath sample is something that the Supreme Court of Canada really needs to clarify. Not only does this provide more certainty for the public about their rights in contacting a lawyer, but it would also help to resolve a lot of conflicting case law in the context of different judgments from different provinces about the interpretation of what happens when police say you can contact a lawyer before providing a breath sample, but then don't give a person the opportunity to do that. Ultimately, the Supreme Court of Canada missed an opportunity to clarify a pretty important legal issue, and one that affects people that are less likely to be involved in the justice system, the type of people that need more clarity about their rights because they're less familiar with the process. Hopefully, the Supreme Court of Canada takes the opportunity in the future to do another case involving the right to counsel and providing a breath sample and clarifies the nature of the extent of the suspension on that right. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazenville Creative for putting together these videos. Please like, subscribe, and share with your friends.